Daniel Ruiz claims he accidentally painted the kitchen the wrong color in a home that was for sale, but he repainted it and still wasn't paid for the job. Michael Lee says the plaintiff's sloppy work made him lose out on offers on the home.
Okay, Mr. Ruiz, you are suing Mr. Lee for $675 remaining on a painting contract that, according to you, he has not paid.
Yes.
Tell me what happened.
So I had got in contact with Mr. Michael here through a client. The client had liked the work that I did, referred me to Mr. Lee, and then we got to work. Monday.
Now, he had you do what?
He had me paint the kitchen.
Okay. Now, you're a realtor?
Yes.
Okay, so it's not your kitchen?
No, it's a house that I'm selling for on behalf of a client.
Okay, go ahead.
So once that started happening, we got in contact, got everything prepped. Wednesday was the...
Wait, so you agreed that you're going to paint the kitchen, and how much are you going to charge?
It was $675 up front. I did agree, $675 up front, and then $675 on the back end once the job was completed.
Okay, so what happened?
So what ended up happening was we went over a couple of swatches. We narrowed it down to 2. I had a swatch in my hand, and there was a swatch on the wall. I misunderstood. I had a swatch in my hand, pointed it towards the swatch on the wall, and I asked Mr. Lee, "Is this a swatch?" He said, "Yes." Like I said, I'll take the hit for it. I understand.
You thought you were referring to the one in your hand,
Yes.
and he was referring to the one you were pointing at, which
Yes,
was on the
ma'am.
wall.
Yes, ma'am.
How do mistakes like this happen? It's so easy. Just have him sign the back of the swatch, you know?
Yeah.
From now on, do that.
Here is the
Go ahead.
first major legal pressure point. The agreement was straightforward. $675 up front, and another $675 when the painting job was completed. That means the court is not deciding whether a contract existed. Both sides agree that it did. The real dispute is whether the contractor substantially performed the agreement, and if the work was not perfect, how much the customer may reasonably deduct for the remaining problems. That distinction matters. A customer cannot necessarily keep the entire unpaid balance because part of a job was flawed, particularly when the contractor offers to correct the mistake at his own expense. At the same time, the contractor is not automatically entitled to every dollar if the completed job still requires repair or cleanup. As this unfolds, focus on 2 questions. Did Ruiz ultimately provide the agreed color? And what would it reasonably cost to fix anything he left unfinished?
From now on, do that.
Okay.
Go ahead.
And after that, I went ahead, I got it done. After I finished up, Mr. Lee came, checked the paint on the wall, and he contacted me later on that day saying, "Hey, this is wrong." I told him, I think I know what happened. I got in contact with him, and then after that, I told him I would have Thursday, Friday, and Saturday to get it all done. So it's ready.
By when had he wanted it done?
Sunday. Sunday was the open house that he had.
Okay.
Yeah. I told him I would schedule.
So you told
Ruiz
him
says
that
he held one swatch in his hand while pointing toward another swatch on the wall. Lee apparently answered yes, but each man believed they were discussing a different color. The judge immediately identifies a simple prevention method: have the customer sign or initial the exact swatch, and keep it with the project records. That does more than avoid confusion. It creates clear evidence of what the customer selected. Right now, neither side has perfect proof that the other person alone caused the misunderstanding. Ruiz accepts responsibility for applying the wrong color, but the original conversation appears ambiguous. Do you believe the contractor should bear 100% of the blame because he applied the paint? Or should the realtor share some responsibility for approving the color without clearly identifying the correct swatch?
Told him I would schedule.
So you told
Thursday.
him that you would buy the paint and you would do the job over?
Yes, ma'am.
Okay.
Thursday came around, and he couldn't. He was in a yoga class, so he couldn't attend. That took away some time for me to get that job done.
Okay. Why couldn't you just why could he not paint anything on Thursday to fix it Because you had a yoga class?
No,
I mean,
well, I definitely hear you, Judge, but he already made a mistake by
Yeah.
simply painting the wrong color, which I think is the basics of, what his job is. And so then I felt I always had to be present because we only had a limited amount of time before the open house. So
but you
I
didn't
wanted-
make yourself present. You went to a yoga class,
Well,
which I
no.
think is very important. I'm
Yes.
just trying to understand why there's no work done Thursday to correct the problem, particularly when the contractor's saying, I'll take the hit, I'll correct the problem, and you say, okay, why then on Thursday does it not happen?
I told him on Thursday after the yoga class I could come to come across town to open the door
Okay.
so he could have 2 hours
and then
to paint.
did you do any work on Thursday?
No, I wasn't able to. By the time he had got back, it would have been late.
Okay, so then what happens on Friday?
So on Friday, I get there and I let him
At what
know.
time had you agreed to get there?
I had got there at 9
Okay,
a.m.,
but
I
what
believe.
time had you agreed to get there? 9?
9.
Okay, do you agree that that was the agreement, that he'd be there at 9?
Yes, we had discussed
Okay, and then
the
what
morning.
happened?
He showed up an hour late. Kind of asked. He said he had some personal things
Now the
going
dispute
on.
shifts from the original mistake to what happened after that mistake was discovered. In legal disputes, an injured party is generally expected to take reasonable steps to limit or mitigate additional damage. Ruiz offered to purchase the replacement paint and repaint the kitchen before the Sunday open house. That offer helps his position. Lee says he wanted to be present because the contractor had already made a serious error. That concern is understandable. But the judge is identifying a contradiction. If correcting the kitchen was genuinely urgent, why make access more difficult on Thursday? Attending a yoga class is not wrongful by itself. But when a deadline is approaching, availability becomes part of the reasonableness analysis. Would you have trusted Ruiz to work without supervision after the wrong color mistake? Or would you also have insisted on being there while he corrected
He
it?
said he had some personal things going on, and so he got there at 10 o'clock, and he
So
showed
what
up
were you
with-
doing for an hour?
waiting for Mr. Lee to get
All
there.
right, and when he got there, what did he say or do?
He said he had some personal things to do, and he had to stop by a coffee shop to get some lattes.
Oh,
Yeah.
all right. Were you an hour late to that meeting?
I will say yes, but there was traffic in the morning. It was a Friday morning, so
An hour late's very late.
traffic. Yes, but if
Did you reach out and call him or anything?
I did not because
Right, so how do you know he's not going to just walk off and say, you know what, this clown I'm not going to do anything for him, forget it. How do you know that you are not going to have the wrong color there for Sunday's showing?
well, that's why I was going there to make sure and managing what he was doing. so
I'm
he could
sorry.
do it
My
right.
question is, why would you be an hour late without calling for anybody, for any reason? But in particular, when a contractor who has goofed, according to you, he goofed, we're going to take it as gospel, who has goofed, has, instead of making you sue him in court and leaving you high and dry, has said, I will fix it, and has tried to get there. Why would you not get there on time or call and say, hey, I'm 15 minutes late? Why would you get there an hour late? Wouldn't that be a very risky thing on your part? Because most of the contractors I know would have left.
In hindsight, yes, I probably could have called him, but also he could have. This communication works a two-way street, right?
So he should call you and complain that you are late.
Coming up on Justice for the People.
What did he say to you?
Well, he just told me since I didn't do it right the first time, he wasn't going to pay me for the rest of the painting that I did.
So you were going to paint twice for half the money.
And later,
The Peacocks come over to your property and do what?
So they jump on my vehicle and they start pecking in the mirrors, and they've pecked the car, and they've left scratches all over the car as well.
An hour
You'll be
late,
in-
no phone call, and an explanation involving traffic, personal errands, and a latte stop. That creates a serious credibility problem for Lee. He says he needed to supervise Ruiz closely because the open house was approaching, yet he left the contractor waiting outside for approximately an hour. The judge is not excusing Ruiz's original mistake. She is examining whether Lee behaved like someone who was genuinely desperate to have that mistake corrected. In court, a person's actions often carry more weight than their later explanations. If the repair was truly critical, a quick call or message saying, I am delayed, but please do not leave, could have protected the schedule. Instead, Ruiz remained at the property when many contractors might have walked away. Who made the situation worse after the original mistake, Ruiz who selected the wrong paint, or Lee, who delayed access and failed to communicate? Give us your verdict before the judge gives hers.
Over the car as well.
If you'll be in the Los Angeles area and want to bring your case to court, call 1-888-552-6878. You're watching Emmy-nominated Justice for the People with Judge Milian. We're back with a dispute between Daniel Ruiz and Michael Lee over a bad paint job.
Friday you painted.
Yes.
Okay, and then what happened?
And then so I didn't get to fully finish by Friday. I was running
Why
on
not,
a tight
though?
schedule. I was running on a tight schedule. I had another client lined up. Saturday I finished up the painting, and as soon as I finished, I talked to Mr. Lee about the payment, and never received the back end of it.
What did he say to you?
Well, he just told me since I didn't do it right the first time, he wasn't going to pay me for the rest of the painting that I did.
So you were going to paint twice for half the money?
Well,
Right, that's what he was suggesting. Now, what happened? What was wrong? Why wouldn't you pay the rest of the money? Because that's the understanding, is that you're going to get exactly what you want. He's going to paint twice. He's not going to charge you for the time, and he's not even going to charge you for the paint. He's going to eat all that. So why wouldn't you pay him?
Well, we had an agreement and an expectation of the way that place would be painted. And I actually have documents and evidence that show that the house was not painted properly. There was still tape on the doors. So when Sunday arrived for this open house, basically the house still looked like a mess. So
When did you check the house?
Sunday, right
That
for the open
statement
house.
captures the heart of Ruiz's lawsuit. He says Lee expected him to paint the kitchen twice while receiving only half of the agreed price. A contractor who makes a correctable mistake may still be entitled to recover the contract balance, reduced by the reasonable cost of fixing any remaining defects. One error does not automatically give the customer a completely free project, especially when the contractor absorbs the additional labor and the cost of replacement paint. But Ruiz still has another hurdle. He must show that the corrected work was completed well enough to justify final payment. Lee is now arguing that the kitchen remained unfinished when the Sunday open house arrived. That moves the case away from the wrong color and toward the quality of Ruiz's final cleanup. Watch the evidence carefully, because the photographs, and Ruiz's own answers, may determine whether the judge awards the full balance or deducts money for unfinished work.
Sunday, right for the open house. So, because of his mistake, there was not enough time to make sure everything.
Well,
could be
that or
double
yoga
checked.
and lattes, but I don't know. All right, so you have Exhibit B that you'd like to show me. The tape. So what we have here is what?
So that is the kitchen countertop, and as you can see, there's so much paint that was dripped and left over all over the kitchen countertop.
I don't know. I don't know if these are paint.
Yes. So
paint
all
spills.
that-
Did you leave that paint spilled all over the counter?
yes, that I did do. I explained to Mr. Lee that I could get that out, no problem.
Well, why didn't you just get it out rather than leaving?
It was a pretty decent sized kitchen. I tried making sure all 4 walls were painted.
Right, but then you call him to get payment when you know that you're not done, because according to you, this is something you can go back and do. Well, why not just do it before you leave?
That's true. I could have done that.
And why
I'll
would you
admit that as
withhold
well.
50% of the payment when it's not going to cost you that to get that fixed by a different painter?
Well, I also think, time is money, right? So the time, and effort, and the energy that, I lost.
It takes to paint the place twice?
Well, like the commission.
He says that he had a thing in his hand and he said, is this the one? So he's like taking the responsibility for the error, but do you understand? Is that how it went down? He had a swatch in his hand and you meant the one on the wall?
He was pointing at the wall.
Right,
And
with a
the
swatch
paint-
in his hand.
Yeah,
Like
but
maybe you're both like kind of responsible for the.
And there is
for
the
these-
contractor's weakest moment. Ruiz admits that he left visible paint on the countertop. He also says that removing it would have been easy, but he failed to do that before requesting the final payment. That damages his argument that the project was completely finished. A professional painting job does not end when the wall color is correct. It ends when the tape, paint drips, spills, and other worksite materials have been properly handled. However, that admission does not necessarily justify withholding the entire $675 balance. It may justify deducting the reasonable amount required to clean or repair what Ruiz left behind. Notice how both parties now have damaging admissions. Lee made access and scheduling more difficult, while Ruiz left the property with unfinished cleanup. This is why civil judgments are not always all or nothing. The court may recognize that most of the contract was performed while still reducing payment for incomplete details.
Kind of responsible for the slack-jawedness of the error as a, like, really, why not go this one, like, why not be sure of what you should be having every client sign on the back of the swatch, and you keep the swatch.
I was expecting the swatch.
It sounds to me like you were really angry and then you stayed angry instead of just figuring, let's get this over with and fixed.
I wanted to find the fastest solution possible to get the job.
The fastest solution possible, okay, is for you to skip yoga, let him in, or let him in before yoga, or let him in after yoga, or just try to make yourself available and then never use him again. That's the fastest solution possible. Or don't stop for lattes for 45 minutes to an hour and keep him waiting, because most people in his position would have just left. They wouldn't have stayed there. So you are not looking for the fastest. You're looking for the one that gives you the most joy. And the one that gives you the most joy is the one where you punish him repeatedly for something that seems to be kind of both your faults. But in any event, let us move on from that and let us move to this. At a minimum, I agree with you that he shouldn't have left it that way. Now, how much is it going to cost another painter to come in and fix that? Or a handyman? You don't even need another painter. Well, maybe you need another painter. How much is it going to cost you?
Probably the same, if not.
No, it's not. No, it's not. I don't think it is.
That's not my, I sell houses and I know
but what did he do? Did he ruin your showing?
Yeah, I would say that, we probably could have gotten more offers on the house.
Oh, so you got offers anyway?
We did, but, I think they could have been much higher. And,
because people who are going to buy a house are going to not buy the house.
The judge has now identified what may be the most important emotional issue in this case. Lee appears to have remained angry and turned the correction process into punishment. Courts generally award compensation, not revenge. The purpose of contract damages is to place the injured party as close as reasonably possible to the position they would have occupied if the agreement had been performed correctly. It is not to provide a windfall or allow someone to impose an additional penalty because they are frustrated. Lee's yoga schedule, late arrival, failure to call, and latte stop weaken his claim that every delay was caused by Ruiz. Ruiz is still responsible for applying the wrong color and leaving cleanup unfinished. But Lee must connect any additional financial loss to credible evidence rather than anger or speculation. Is the judge being too hard on the realtor, or is she correctly calling out behavior that unnecessarily made the problem worse?
A house are going to not buy the house over a little paint thing like that gets resolved in, a couple of hours.
I sell a vision of people.
I know you sell a vision. Do they have eyeballs? Because if I look at that, I say, yeah, that needs fixing. But I don't not buy the house over it, because the house is the house. That is a fixable problem. It's annoying, but it's a fixable problem. Do you really expect me to believe that there were people who would have made an offer but for the paint?
I hear you, Judge, because if they see small mistake like that, they're going to assume there's deeper mistakes within the house. And so that's where I think we're going to lose out on more clients.
Okay, good argument, but you don't win on that. I am going to assume that it is going to cost you at least $250. I am going to order you to pay the defendant for the rest of the job minus the $250 I think it's going to cost to clean up the things that you need to clean up. That's $425. Verdict for the plaintiff.
All rise.
Judge Millian has ruled in favor of the plaintiff. The defendant owes $425.
I agree with the judge, but I'm pretty frustrated about this whole situation.
Nothing on my end.
Exit this way, please. Make sure you grab all of your belongings.
Coming up.
And I'm just putting the food down for the wildlife right in my front yard. But I'm trying to support the ecosystem, and that's something really important to me.
You're watching Emmy-nominated Justice for the People with Judge Millian. Bill Kersey claims his neighbor's birdseed attracted peacocks that scratched and pecked his car. Dusty Sutherland says she puts seeds out to support the ecosystem and has no control over the peacock's actions.
Okay, Mr. Kersey, you are suing your neighbor, Ms. Sutherland, for $1,200 in property damage. What
Here
happened?
is the final financial breakdown of the painting dispute. The unpaid contract balance was $675. The judge estimated that correcting the remaining paint and cleanup problems would cost approximately $250. She therefore deducted that $250 from the amount owed and awarded Ruiz $425. In other words, Ruiz did not receive the full balance because the condition of the kitchen was imperfect. But Lee was not permitted to keep the entire remaining payment after receiving the repainting work. The ruling recognizes both sides' responsibility. Ruiz substantially completed the correction, but left defects behind. Lee had a legitimate cleanup complaint, but could not prove that the defects justified withholding every remaining dollar, or that the condition of the paint caused him to lose specific home offers. Now the courtroom moves from a contract dispute to property damage, where the next plaintiff must connect a neighbor's wildlife feeding to scratches on his vehicle.
Property damage. What happened?
That's correct, Judge. So my neighbor has been attracting a large population of peacocks over onto my yard. She feeds them, I'm talking about large scoops. And so the birds are being attracted, they're coming over to my car, and they are scratching.
I take it there's, first of all,
Yes.
Where does she live in relation to you? Is she next door?
Right next door, yes.
Okay, and I take it there's no fence or anything separating your properties?
Correct.
Okay, so then the peacocks come over to your property and do what?
So they jump on my vehicle and they start pecking in the mirrors, and they've pecked the car, and they've left scratches all over the car as well.
Okay. Ms. Sutherland, why don't you tell me what's going on here?
Your Honor, I have been living in this house that I've been renting for 4 years. And so even my landlord has supported me going ahead and feeding, and I'm just putting the food down for the wildlife right in my front yard. But I'm trying to support the ecosystem, and that's something really important to me. And even my landlord doesn't have any opposition to it.
Okay, what do you think the ecosystem means?
When there's a point in time where they're not able to find the food that's nourishing in their area, it's just an extra supplement for what they need.
Where do you park your car?
Okay, so I have a garage, and my girlfriend moved in about 6 months ago into my property. So now I park my car on the driveway, and so now I've seen them actually peck my car.
Coming up,
They're supposed to be able to control their own population. That's what an ecosystem means, that nobody is messing with their population.
you're watching Emmy-nominated Justice for the People with Judge Millian. We're back with a case of Bill Kersey, who blames Dusty Sutherland for peacock damage to his car.
I have evidence right here.
Okay, and what's your evidence? Talk to me first. Tell me
sure.
what it is.
So basically, I have a picture here of her front yard with the peacocks.
Okay.
At the same time, I also have scratches where you can see the
The
evidence
second
there.
dispute raises a very different legal question. Can someone become financially responsible when wild animals are attracted by food placed on their property and then damage a neighbor's belongings? Sutherland describes her actions as supporting the ecosystem. Kersey describes them as repeatedly attracting a neighborhood nuisance. The important issues will be foreseeability, causation, prior notice, and the amount of damage. Did feeding the peacocks make it reasonably predictable that they would gather nearby and climb onto vehicles? Had Sutherland been told that the birds were creating problems? And can Kersey demonstrate that the scratches were more likely caused by the peacocks than by another source? The emotional conflict is already clear. One neighbor believes that she is helping nature. The other believes that the cost of her personal mission has been transferred onto his property. Which side sounds more reasonable at this stage of the hearing?
Scratches, where you can see the evidence there on my vehicle.
All right, but hold on. I want to see the birds on her property. And, okay, so there's a bunch of birds on her front lawn. And I see that you've got a picture here that you wanted me to see where you're wearing a T-shirt that says you're the peacock lady. Tell me about that. That's...
it's better than just calling the bird ladies, so I went with it, but it's not really the whole purpose of why I'm putting the wildlife seed out.
No, why are you putting the wildlife seed out?
I'm doing that to nurture nature and...
Okay, no, you're not.
And continue to...
I know you mean well, I do. You are not only 100% not nurturing nature, you are endangering nature. It is illegal to feed wildlife in virtually every city. It is illegal in your city of Arcadia, California, and indeed illegal in the entire state of California. You think you are doing a good thing when you feed the pigeons the bread and, the little pieces of bread. You're not. You're doing something that A, is illegal, and B, is creating a nuisance for everybody else, and C, is actually bad for the wildlife because the wildlife then end up depending on human interaction. And they're not supposed to be. They're supposed to be able to control their own population. That's what an ecosystem means, that nobody is messing with their population. And that includes your well-intentioned feeding of the birds.
Judge Million's verdict when justice for the people returns. You're watching Emmy-nominated Justice for the People with Judge Million.
Let me see the damages to your car. Are those feathers?
Yes.
Oh, okay. I'm done. I am going to rule in your favor because the standard in a civil case is beyond and to the preponderance of the evidence. In other words, he just has to tip the scale and show me that it's more likely than not that it's caused by what is happening in your neighborhood. There's absolutely no doubt you're the peacock
This is
lady.
the decisive turning point in the peacock case. The judge rejects the argument that feeding wildlife automatically helps the ecosystem. She explains that human feeding may create dependence, concentrate wildlife in residential areas, and cause a nuisance for surrounding property owners. For this particular dispute, the most important question is not simply whether Sutherland intended to help the birds. It is whether she continued attracting them after learning that their presence was allegedly causing damage. Good intentions may explain a person's actions, but they do not necessarily eliminate responsibility for foreseeable consequences. The peacock lady shirt also becomes unexpectedly valuable evidence. The judge jokes about it, but when it is combined with photographs showing numerous peacocks on Sutherland's lawn, it supports the allegation that the feeding was regular and significant. Should she be responsible for the full repair bill, or should the unpredictable actions of wild animals limit her liability?
Absolutely no doubt you're the peacock lady, because I saw it on the T-shirt, so it has to be true, okay? There's absolutely no doubt you're feeding them, and he's mentioned it to you numerous times. That's enough to tip my scale. $1,200 verdict for the plaintiff.
Thank you.
Thank you.
All right.
Judge Million has ruled in favor of the plaintiff. The defendant owes $1,200.
I'm happy with the verdict.
I just wish we could still support the ecosystem, but I will do my homework.
Okay.
Thank you.
Exit this way, please. Make sure you grab all of your belongings. Ladies first.